So my paper this afternoon is entitled International Courts, the Paradox of Consensual Jurisdiction and the Anthropocene. The proposition really in my paper is that in the face of the enormity of the challenges which we as an international society face, the role of international courts in upholding the international rules on the environment in particular, I think will invariably be found wanting. I'm going to put to one side the credibility or otherwise of the substantive law in this area. I think we can have a very detailed conversation about that, and I'm sure others will be tackling that challenge. My focus is rather different and is separate, and it's rather narrow as well. I'm going to be focused on the normative rather than the strategic considerations or the structural framework for international dispute settlement. So even if we had good law, do we have the appropriate and effective mechanisms to enforce that law? And my particular subject, the role of international courts in resolving environmental disputes. More specifically, should we create compulsory jurisdiction for state-to-state disputes in this area? Apologies that there's a certain amount of introductory material here. There's a certain amount of basic principles that I need to sort of just get across before getting into the detail. So I'm going to very briefly deal with first a brief overview of international dispute settlement from a sort of a public international law perspective. Secondly, some comments on the limitations of adjudication in relation to environmental disputes, particularly in relation in the international arena. Thirdly, how I think the rise of the Anthropocene really does exacerbate these systemic challenges. And then finally, what I think I might describe as incremental glimmers of hope. Reviewing my paper this afternoon, I think I conclude with a certain note of realism, that in a state-based system, we may look to the courts as autonomous agents of change, and they may well be in certain cases on certain facts, certain applications of certain laws. But structurally, which is going to be the focus of my attention this afternoon, I think we need to be a little bit circumspect that the utopian appeal of a compulsory adjudication system is actually in some ways more problematic than it may first appear. So I did wonder actually whether I was in the right theme in some way, and how do we get there? But equally, I think I raise as many challenges as next steps in the move towards the Anthropocene. So the Oslo Manifesto, which I'm sure has been mentioned today, starts with the phrase, environmental law is at a crossroads. I suppose my summary is the easiest route may not always be the right one when it comes to changing public international law. So three general principles at the heart of international dispute settlement, which I think we need to keep in mind. Firstly, as a matter of state responsibility, states are responsible for all breaches of obligations to which they owe, remembering that not all states sign up to all treaties, or all states are subject to customary international law. Secondly, ordinarily only affected states can bring a claim against another state that has caused it harm. The ability of so-called non-injured states to bring a claim remains a growing, yet still contested area of international law, this idea of actio popularis. And thirdly, while there is an obligation on all states to settle their disputes peacefully, there is, in the absence of an express commitment agreed to by the states involved, no obligation to submit the dispute to third-party adjudication. Thus, we can start to develop a rather complex three-circle Venn diagram of whether there is a breach of binding law, whether there is a state which is able to bring a claim and actually willing to bring a claim, and of course that's a whole different question, and whether it can be brought before an appropriate dispute settlement mechanism. I think an important caveat is that international dispute settlement and international adjudication are a long way from being the same thing. Indeed, as I'm sure most will realise, most disputes, even legal disputes raising complex legal questions, are more often resolved through political and diplomatic means, primarily negotiation. Nevertheless, we can't discount the role that international courts and tribunals can play, and there is a growing number of both of standing and ad hoc tribunals. The preeminent body, of course, is the International Court of Justice, but we have other standing bodies, the International Tribunal for the Law of the Sea, the Dispute Settlement Mechanism under the World Trade Organization, regional courts and tribunals, and specialised courts such as the European Court of Human Rights and other human rights bodies, etc., etc. And of course, work going on about ecocide and international criminal law, but I'll leave that to one side for the moment. We also obviously have a prolific ad hoc system of arbitral tribunals, usually but not exclusively set up under the Permanent Court of Arbitration. As the International Court of Justice remains of both rhetorical and perhaps most substantive significance, probably worth saying some general words about that before getting into a little bit more detail. First thing to note, in matters of contentious jurisdiction, the first limitation in relation to the International Court is that it's only open to states. Secondly, and this really does go to the heart of my presentation today, the court's jurisdiction is strictly consensual. It's not compulsory. I need to break this down a bit, but the underlying truth is that the International Court will only take a case where it can find state consent to adjudicate. Now, the most ready form of consent is where both parties have agreed to submit a dispute following the emergence of the dispute. Such consent is normally contained in an agreement, often referred to as a compromise between them. They recognise that there is a dispute between them, but they also recognise that they want to get over the dispute and send it to the International Court. The second means of finding consent is where a prior existing agreement exists, such as the Genocide Convention, which says that all subsequent disputes will be referred to a particular tribunal. A third means, and perhaps this is where we get into some more areas of imagination in terms of where we might go in the future, is that states can opt to submit to the court's optional declaration system, the so-called Article 36(2) system. Here it allows the states to say that subject to another state also issuing an optional declaration, the court will have jurisdiction. But these optional declarations are often excluded with conditions by reason of subject matter or time, etc. In short, there are various ways that the court can find consent, but the key thing is that consent at some point there must be. There is no such thing as compulsory adjudication before the International Court of Justice. Now, there are systems, such as in the UN Convention on the Law of the Sea and the WTO, where it does look a more compulsory type of system. Of course, consent was given when states first signed up to the treaty in the first place. Now, all of this, I think, is usefully summed up by something that drives me wild in about June time, when I'm marking student exam papers. And you read a wonderful exam paper, and it will sort of finish with the line, "Send it to the International Court," as if somehow the International Court is a silver bullet or panacea. And I think for me, that highlights some of the conversations in this area. So I'm not going to spend too long talking about environmental dispute settlement. I think we're all reasonably aware of some of the limitations of environmental cases, and that applies as much as to the international arena as the domestic one. The binary nature of dispute settlement, the need to find a claiming state willing to bring a claim, evidential difficulties, appropriate remedies, etc. And many of these are compounded at the international level. What I want to focus on is this idea of, if we are moving to the Anthropocene, what can we do about consensual jurisdiction? Now, the matter of consensual jurisdiction is, of course, merely a feature of the bigger perennial paradox, that of sovereignty. In a legally flat, yet politically differentiated system, the notion of sovereignty, and more especially sovereign equality, presents real systemic and structural challenges. In addition to the obvious artificiality of the territorial limits of the sovereign state, sovereignty also permeates almost every aspect of how international law is made, enforced, and dispute settled. In tackling the enormity of the ecological challenges represented by the Anthropocene, will a consensual system of jurisdiction prove sufficient? I think there's an underlying assumption here that the more prescient and more grave the threat, the more effective we must make the system. So, for instance, we talk about binding international legislation rather than the voluntarism of treaty commitments, for instance. As my students have said, and as I said before, they often might send it to the ICJ, as if compulsory third-party jurisdiction is the answer. And there is some movement in this regard. So the International Court for the Environment Coalition has a sense that we need a more effective and a more sustainable international court. So if sovereignty is seen as a blockage, its ability to hinder adjudication is equally seen as problematic. To be able to prevent a dispute from even getting to court. But in a curious way, I think such criticism relies on the very notion of sovereignty that most commentators in relation to the environment wish to move away from. Namely, it views international law as directly comparable to the hierarchical and vertical systems of national law. In other words, it is the idea that international adjudication should be compulsory, because international law should be increasingly hierarchical in nature. And it really reminds us of the Austinian challenge that only commands issued by a singular sovereign, backed up by the sanctions of law, really can be called law. But we don't have that Austinian sovereign. So what would compulsory jurisdiction achieve to deal with the challenge of the Anthropocene? On the surface, making international courts or giving international courts compulsory jurisdiction is per se, I think, seen as a good thing, holding states increasingly to account for their violations of international law. I think one needs to see consensual jurisdiction in the wider round. How is international law created? Who is able to enforce it? And how are court decisions respected? And I think each of these other things would potentially become more difficult if we move towards compulsory jurisdiction. States may become less ambitious in their obligations in the first place. They would tighten the rules on who could enforce international law. So the developments we've seen on Actio Popularis. And of course, in relation to post-judgment enforcement. And of course, this is always seen as the Achilles heel. There are very few effective routes to post-judgment enforcement in international law, particularly as regards the International Court of Justice. And yet, the majority of states respect the judgments given down. They do so for political, economic, good standing reasons. Would compulsory jurisdiction at the award stage change this dynamic? I think so, yes, and I think so quite considerably. Whilst we do have a few examples of post-judgment enforcement, and the World Trade Organization is a really good example of that, it really is an exception. So unless we're prepared to change the fundamental ideas behind the system itself, i.e. territorial sovereignty, I think changing one component part of that may actually be counterintuitive. I suppose that's my sort of key point. So it's a relatively realistic perspective, but there are some glimmers of hope that I'd want to throw into this rather dismal gloom. The first is that the International Court of Justice and tribunals have never been busier and have never been busier on environmental disputes. And the jurisprudence, to a large extent, is becoming more proactive and actually reading the law in more imaginative ways. There are regimes which we could think to borrow from. I think the international dispute settlement regime under the UN Convention on the Law of the Sea, which does have a form of compulsory jurisdiction in a large part of the convention, but balanced against state choice as to which mechanism they choose, arbitration, tribunal, or the International Court of Justice, may be something to reflect further on as we move forward. We see greater use of interim and provisional measures pre-judgment. And also, it's not all about compulsory or contentious jurisdiction. The role of the International Court of Justice and the International Tribunal in giving advisory opinions. We've had them in relation to nuclear weapons, the Israeli war, the Universal Declaration of Independence by Kosovo, something that is particularly of interest to me, the recently requested advisory opinion on the Chagos Islands. I think all reveal the importance of the legal authority in these areas of advisory jurisdiction. Also reveals the communitarian nature, I think, of dispute settlement, that the international community as a whole, often through the UN General Assembly, had an interest in legal enforcement. Realise pushed for time, so I'm going to conclude. There's no doubt that humanity as a geological agent is now a game changer, and we need to find ways to better hold states to account for that. And international courts, through their judgments, are showing themselves to be capable of that when they get the cases to them. What is less certain is whether incremental change of one aspect, consensual jurisdiction, without regard to the wider normative and political context, will necessarily make anything better. As Voltaire said, the perfect may be the enemy of the good. Now, that's not to abandon reimagining of international adjudication at all, or consider how we can strengthen it. Plenty we can do with human rights courts, see how we can bolster non-compliance with multilateral environmental agreements. I'm starting to think about how the investor-state arbitration system might be redesigned to allow NGOs access to challenge directly states. But on the singular matter of state-to-state adjudication, I think compulsory adjudication is a little bit of a red herring, and it will remain illusory unless the sovereignty of the state is itself going to be challenged. But that's a different presentation. Thank you.
Questions, comments, suggestions? Yes.
Can you say just a little more about how NGOs could be part of the investor states disputes settlement mechanism?
Thank you for the question. That was a very late add-in. So I was teaching a class on investment law this afternoon, and I was teaching the sort of basics of investor-state dispute settlement. And as I was teaching this and then thinking about what I was doing this afternoon, it just occurred to me that, you know, we give very effective mechanisms for foreign investors, but the model, the system, could easily be adapted if the political will was there, but NGOs to challenge more effectively and more directly. So, you know, we've got a system in place which is arguably the most effective form of dispute settlement in the international system, but we have only opened it up for foreign investment. That's a political choice.
Good point.
Kirsten, you wanted to say something?
I will let you go, and it's been a really interesting conversation, but the only thing I would add was I have never heard conversations about investor-state dispute settlement when the European Union member states were negotiating with developing countries. It was only when the EU realised it was going to itself be subject to investor-state provisions that we already started to think of more innovative functions. So I think there's a certain amount of double standards there.
Yeah.
Anyway, thank you for your opportunity to take part.
Thank you.
Excellent.
So I think we'll